Okay, welcome everyone. Good morning. My name is Onome. I'm a senior content associate at CareerBuddy. So nice to have everyone join this call today. You can just drop in the chat your name and where you're joining from, majorly, so we get to know each other before we get started. So your first name and where you're joining from, and maybe just expectations for this call, why you thought to join this webinar very quickly. Please, let's engage the chat. So please. Looking forward to it. Hi, Chisom from Owerri. Nice to have you here. So majorly today, we're here to learn about employee rights. When aptResponse reached out and said, oh, they wanted to, educate our community members about employee rights, I'm like, we really need this because there's a whole lot going on in the corporate space. So many shiggas being seen, so many unfair treatments. So I'm super excited that we all get to learn today about just how to react or how to respond to unfair treatment, or how to just even know how to speak up for yourself in the corporate space, because it's really, really important. So welcome Mataya from Lagos, welcome Olasekomi from Abuja, welcome BC from Ibadan, welcome Maria from Lagos, and welcome John from Lagos. Nice to have you all join the call today. So I would have the thought leaders from aptResponse introduce themselves in a bit. But before that, just a brief icebreaker for today. So I have a question for everyone today. Like, what is the most unfair thing that has been done to you in the corporate space? Like one very like, wow, is this me that this happened to literally? So just drop in the comments, what's the most unfair thing that has been done to you in the corporate space? Let's have that going in the chat. So while I introduce our thought leaders. So hi, Judith, could you please introduce yourself, what you do, and just like get us to know a bit about your experience and work so far?
Okay, hi, good morning, everyone. It's really a pleasure to be here and to have this conversation or interaction, right? So basically, my name is Judith Izonu. I am a legal practitioner. I work at Primary Africa Legal in Abuja. And also the Social Secretary of Nigerian Bar Association Young Lawyers Forum. The forum that is also collaborating with aptResponse, right? So, yeah, basically I'm a lawyer, so I just do the legal work. It's really nice to be here. Yeah, I must say so. Thank you for having me.
Thank you so much, Judith. Hi, Gabriel. Do you mind introducing yourself to us?
All right. Thank you very much. I'm excited to be here as well. So my name is Gabriel Agbola. So I'm a lawyer based in Abeokuta, where I run my own practice. So I'm the assistant legal secretary of the NBA Young Lawyers Forum. So I'm again glad to be here. Thank you for having me.
Awesome. Thank you so much, Gabriel. Nice to have you here. So I don't see anything in the chat box. No shiggas have been seen, no unfair treatments. I don't see anything. So if you want to share, please just share that now in the chat box. The most unfair thing that's happened to you in the corporate space. Let's engage. Oh my God, trust me, it's a safe space. HR is not watching. You're safe. Don't worry. Just feel free to share. All right, not to waste our time. So we'll just get started with okay, I see something from Juliet. Found out some of my colleagues got transport allowance, but nothing for Wow. Wow. Interesting. They put my role for a while. I was seeing, maybe, they wanted someone to support you or something. Okay, any more stories? Anybody? The worst unfair treatment I've received so far. I was not posted to any location. I waited until I was posted. That means I did not go to work for a day. I reached out and there was no response. I called and sent text, but no response. Bottom line, I was debited 30% at the end of the month for not going to a random location, the HR said. This story feels like there's something that should come before it. I don't really have a full grasp of it. Precious, do you want to unmute and share what really happened? Anywho. Okay, you want to please go ahead and share then. Let me.
Okay, good morning.
Good morning.
Okay, so my name is John. It happened that I work as an auditor, as a field auditor.
Okay.
Okay, I think I was a trainee as at then. I work as a field auditor, so I was a trainee. So normally they would post me from one business location to another.
Okay.
So I expected that posting and I didn't get it. I just finished with another previous business location a day before.
All right. So
For the next day, which I did not get. So I sent a message, sent calls, but no response. So at the end, okay, so I didn't go to any place at that day because I understand the fact that I can't just walk up to any business location that I was not posted to. So that's what we're taught from experience and what we're taught in school. Because I'm not protected, I'm not covered, I'm not supposed to be there because I was not posted there. So at the end of the month, I didn't go to any place. So they called me that at the end of the month, I was debited 30% of my salary. That I should have gone to a random business location to operate. So I was like, wow. So if anything happened to me at that business location, maybe I got injured or anything happened, God forbid, or maybe there was a loss or something that happened, even not to me, even if it's at that organization, then the police would come and meet me and tell me that what was I doing there? Was I posted to that place? How do I defend myself in that situation? Or let's assume something happened to me, or obviously nothing bad can happen to me. So let's assume someone somewhere went to a business location and he got injured. And then the company can say that they did not post it there. So in that situation, does it justify the 30% disciplinary action that was taken against me for not reporting to any duty that I was not in? First instance, I was not posted to. So that was a lot of things that was going up in my mind. So after I was debited, because with that day, I thought about it. I can't just walk out to any business location because it would be wrong of me. I can't prepare a report. I can't send an audit report because I was not posted there. Then what will I be doing when I can't send the audit report for a place I was not posted to? So by the end of the month, they debited me. So I felt it was wrong. So I just said, let me throw it out here I'm still working with the company because I didn't take it so personal. I just felt it was the wrong decision making from their part, from the management part. I'm still working there, but I just felt I could have left, but I didn't take it so personal. So I'm still there, and this is like.
Awesome. Thank you so much, John, for sharing. I'm sure you get answers to like the question whether it's fair or not as we move further in the webinar. Thank you so much for sharing.
Okay.
So to move ahead, we would have just a mini session on just like general understanding your general legal rights. So just stay tuned because you would get the opportunity to ask all of your questions. We've got a ton of questions, and this is the place to ask for free and get answers for free. So just stay plugged in. I would be bringing up the speakers from aptResponse to just give us general information about our legal rights before we go to the Q&A session. Thank you. Hi, Khadija.
Okay, so I don't know, Khadija, do you want to say something?
Oh, I think you can just go, Judith. You can just go then.
Okay, so thank you very much once again for having us. So just like you said, just like the moderator said, we're going to be talking about the employment rights, you know, how you understand your rights as an employee. So because of how broad this topic is in the labor law, we have tried to outline it into 4 parts. So we're going to talk about the laws that are applicable to employment, tips to having a fair and respectful workplace. Of course, we'll now talk about the primary rights of employees and the termination of employment, right? So I'm just going to speak on the first 3 parts while my colleague will talk about termination of employment. Please confirm that you can hear me.
Oh, yes, I can.
Okay, thank you very much. Thank you for that. So, yes, employment rights are rules that protect you at work, you know, simply put. They cover things like your pay, your working hours, your safety at work. So it's very, very important that you know your employment rights, you know, because it can help you to stand up for yourself. Just like, is it Mr. John or Precious, person that talked about how he was debuted and all of that, you know, he didn't say anything about it at the end of the day, just decided to, okay, let me just continue with the company, you know, because he's not supposed to get such unfair treatment from the company. You know, he's not supposed to have that deduction without any reason to justify that. So it's important that we all understand our rights, you know, to ensure that you're treated fairly at work. So we'll try as much as possible to highlight the primary rights of employees, you know, the ones that you should have at your fingertips, and don't allow anybody to intimidate you. So, but before I go into the laws that are applicable, I need you all to understand that in the Nigerian law, the Nigerian labor law specifically, so there are 2 broad categories of employees, right? So they are the ones that are defined under the Labor Act as workers. So if you don't fall under the category of workers, then the Labor Act does not apply to you. So the non-workers are the ones that, you know, are now being guided by their terms of employment. So because under the Labor Act, the workers are defined generally as people who, you know, employees that perform manual labor or clerical work. That is the definition of workers in the Labor Act, right? So, but for other employees who perform like administrative, executive, technical, or professional functions, they are referred to as non-workers, and they're basically not, you know, in quotes, protected by the Labor Act. So those non-workers now make reference to their terms of employment. So that's why it's actually important that before you are employed, or say you're already employed, you have to understand the terms of employment, especially when you don't know if your scope of work is protected by the Labor Act or not. But generally, just advisable that you understand the terms and conditions at which you're employed, you know, because most times your non-workers are primarily subjected to their terms of their employment. So if there are areas, if there are provisions, if there are conditions that you do not understand, feel free to ask the HR, the the head of department or the managing partner or whoever to explain. Be sure that you understand before you sign that, because most of the times you realize that it's after you have signed the terms of employment that something now happens, and you now be like, oh, but that was what we agreed, and you don't know that you actually had that agreement. So I'll now highlight the laws that are applicable to employment in Nigeria. Of course, the Constitution of the Federal Republic of Nigeria, makes general provisions on fundamental rights, on our fundamental rights. I'm not going to start talking about the fundamental rights because it's going to take our time. Then the Labor Act, as I've already mentioned, makes general provisions as to protection of wages, your contract of employment, and terms and conditions of your employment, right? So remember again that the Labor Act, technically covers people who fall under the definition of workers in the Labor Act, right? Then the Trade Unions Act, this makes provision for, formation, registration, and organization of trade unions. Trade union is any combination of workers or employers for the purposes of regulating the terms and conditions of their employment. You have like the nurses union, the drivers union, you have the Nigerian Union of Teachers, Nigerian Union of Journalists, ASU, NASU, all of them are all trade unions, right? Then the Employees Compensation Act is an act that makes provision for compensation for any death, injury, disease, or disability that arise out of or in the course of employment and for related matters. So if you have incurred injury or disease, disability, or somebody dies in the course of their employment, you are entitled to compensation by your employer, of course, with as stipulated in the Employees Compensation Act. Now, there is also the Trade Disputes Act. This specifically makes provision for settlement of disputes and matters that are related thereto. So in the trade dispute, I find that there are procedures for settlement of trade disputes. So parties who are at loggerheads can first appoint a mediator to try to settle their disputes. In events that the mediation fails, then the Minister of Labour may now appoint a conciliator. So these are like alternative dispute resolutions, right? So the minister appoints a conciliator who tries to settle the disputes. In events that the conciliation fails, now the minister can refer the dispute to an industrial arbitration panel, which at the end of the hearing will issue an award at the end, right? And parties are expected to abide by the award. But in the event that any of the parties files a notice of objection to the award, then the minister shall refer this dispute to the National Industrial Court, right? So the award of the National Industrial Court shall be binding on the employer and the employees or workers, as the case may be. So you see that the National Industrial Court has the original jurisdiction to entertain matters that are connected to or related to labor, employment, trade unions, matters arising from workplace conditions of service, including health, safety, and of course, welfare of employees, right? But before going to the National Industrial Court, it's always advisable to explore any of the alternative dispute mechanisms that I've already mentioned earlier. But it doesn't, prevent you from just going straight to file an action at the National Industrial Court, right? Then we also have the Pension Reform Act 2014, makes provisions relating to pension, and the Factories Act, right? So these are like the primary laws or legislations that make provisions for employment and employment-related matters in Nigeria. Now, I'm going to briefly talk on tips for having a fair and respectful workplace. First off, you need to understand your rights as an employee, right? You need to understand that there are some things that your employer cannot just say, oh, we cannot do this, because it amounts to jeopardizing your rights as a person. So when you understand the rights, which we're going to talk about shortly, it will actually help you to ensure that you're not treated unfairly. Then secondly, you need to understand the workplace policies and procedures of your company or organization or wherever you're working. So try to familiarize yourself with the employee handbook if they have any. Understand the principles or rules or policies that are existing in these corporations, because when you don't and anything happens, they will always make reference to that, right? So, and while you familiarize yourself with these policies, try as much as possible to also stay updated, with the changes or the policies and procedures. Ensure that you're updated with the latest information, things that happen. Just stay informed generally, right? Then try to communicate. Can you hear me? I think
Yes, I
I'm
can.
hearing like
I can.
a background noise or
Yes, we can.
something. Okay, thank
Yeah,
you.
just
Okay, so try as much as possible again to communicate effectively. Communicate with your HR. So I'm going to also make reference to Mr. John that talked about the deduction from his salary. He could have also gone to the HR to ask, why was my salary deducted? Try to even find out why. Explain to them that, you didn't get any mandate to go to another location. Ask questions, be specific. Don't hesitate to reach out to the human resource department for clarifications. Because imagine that you just keep quiet. It's something that can happen again, right? Because they've already seen that, this person doesn't even know what he's entitled to. He doesn't know his rights. So they can always do that to you again. So try as much as possible to speak and ask questions, Then, of course, while you're doing that, while you have concerns in the workplace, procedures, you follow the chain of command, because there are companies that have like a hierarchy or structure of how you go about issues or challenges that you're facing. So, and endeavor to, follow the proper channels within your organization to relate your problems. Then, of course, exhibit respect and correct behavior at your workplace, because you don't want to give your employer something to hold on to. They always say, because you did this, because you did that. So try as much as possible to be at your best behavior, carry out your work diligently and all of that. And you see that you know your rights, see that nobody would want to, trample on that. So having said that, I'll now move to the primary rights of employees, So the primary rights are typically a range of protections and entitlements that ensure a fair treatment in the workplace. And these rights, somehow they vary depending on the country and the applicable laws. So I'm just going to be specific on the Nigerian laws and the rights that are being provided therein. So first off, you have a right to a safe work environment as an employee. You are entitled to a workplace that adheres to health and safety regulations so as to minimize the risk of, accidents or injuries to the employees. Do not put yourself at risk because you're trying to work or because you don't have an option. Just make it known that, this thing is detrimental to my health. I can't be in this environment working like this, in a very polite way. Mention it to your employer or the HR, because you have a right to work in a very safe environment. Secondly, you have a right to fair compensation, right? Employees should receive, fair pay for their work, right? Then you have a right to non-discrimination. This is even provided in the Constitution. Have a right to be free from discrimination of any sort based on your gender, race, sex, religion, origin, age, disability. You're not supposed to be discriminated for any reason. There should be equal opportunity for promotions, for compensation, increase in pay, trainings, and all of that happens in the organization or your company where you work. So there shouldn't be any sort of, when you sense that you're being discriminated, maybe because of your gender or because of where you are from. The owner of the company is from Enugu, for instance, and then is now being more favorable to people who are from there. But because, oh, you are from Lagos or somewhere that is not in the East, they feel that it shouldn't be part of the trainings or promotions or compensations that arise. No, it shouldn't happen that way. You have a right to non-discrimination as long as you're working in the organization. Then you have a right to privacy, right? Even the Constitution, again, makes provision for this. As an employee, you have certain rights to privacy in your workplace concerning your personal information and communication, but this can be balanced. This right can be balanced against the employer's right to monitor the business operations, because the employer has a right to check through maybe your emails to be sure that you are complying, especially when you have a work email, right? The employer has the right to check to be sure that you are complying with the company's policies and not going beyond what the company's motive or vision is. So, but generally you have a right to privacy. Then you have a right to association, to join any trade unions. You can decide to join. Your employer is not supposed to compel you to join any association. It's your fundamental human right to belong to any association. So if you feel like you don't want to, then don't. You don't have to be compelled to join any association. Then again, you have a right to medical leave without fear of losing your job, because I see that, or I hear that some people are always scared when they are sick, they're always scared to ask for leave or permission to treat themselves, because they'll be like, oh, maybe when I go, they will now give up my job to somebody else. No, you should be entitled to medical leave, every year, right? To be sure that you check yourself. As a matter of fact, I even know an organization that do like an employee check, for their health. They do like employees' health check. They bring in medical personnel to check their body system, check your high blood pressure, check that everything is intact. So you have a right to that medical leave, because at the end of the day, if anything happens to you, the company will move on. Trust me, the company will move on. The only thing is I probably just accord you some respect. Let's just do 1 or 2 minutes silence to observe this person, and they'll move on and replace your position. So be sure that you look out for your health. Whenever you think that you need to run a medical check, always ask for that medical leave, right? Then you have a right to fair treatments. As an employee, you should be treated fairly, free from any sort of harassment, bullying, unfair disciplinary action, what have you. Okay, I read that somebody said they gave her colleagues transport allowance and they didn't give her. That's an unfair treatment, because if you all went for the same work or traveled for the same work, and some persons received transport allowance and some persons didn't, it's an unfair treatment, right? Which shouldn't occur. So it should be treated, all employees should be treated fairly, free from any sort of harassment, right? Now, specifically on Labor Act provides that wages or salaries should be payable in legal tender, either by check, by transfer, or postal order, and not in any other way, because anything that is contrary to that is illegal. So you have a right to receive your wage or your salary in legal tender. It should not be in kind, right? Then the content of your contract of employment should be specific. I know that the law recognizes that contract of employment could be oral, it could be written, it could be implied, and it could be expressed, but it's advisable to have a written contract of employment, because it makes it easier for you to reference and it is more specific. So have a written contract of employment, which will contain the name and address of your employer, your employee, your place and date of engagement, the nature of your employment, right? The dates. I mean, if your employment is for a fixed term, you have a date that it should expire. You shouldn't extend beyond that, except if you have an agreement with the employer, of course. You should have a notice period specified in the contract. the rate of wages or your salary should also be specified, so that when they start paying you lesser than what you should earn, you should be able to speak up. The rate and how it's being calculated should be specified. If you're entitled to, the procedure or mode of promotion or, increments in salaries should also be specified. This is usually, based on the company's policy, but it's good to have it stated in the contract of employment. Then the terms and conditions, of course, the working hours should be stated. If you're working beyond the normal, say for instance, your employment, in terms of employment says you're working for 8 hours in a day, and if for any reason you work beyond that, that results to overtime and should be stated if you are to be entitled to pay for working overtime or not. Your holidays, your holiday pay or sick leave or your annual leave should all be stated in your contract of employment. If there are any special conditions of the contract, that should also be stated. And you should be able to understand these terms. If you don't, that's why it's also advisable to have like a lawyer or a legal practitioner interpret this contract of employment for you before you find yourself in the company. So you don't say, oh, I didn't know that this was included. I didn't understand it this way. I thought this was what they meant. So always ask questions. Again, speak up. If there are areas that you're not clear on, ask the HR to explain what that is. Then the termination of employment. So the contract of employment should also specify how the employment can be terminated. I'm not going to talk so much on this because my colleague is going to talk about that. Then, of course, if you're required to travel, outside your workstation for more than 16 kilometers as provided in the Labor Act, then you should be entitled to a transport allowance, right? It's supposed to be part of your rights as an employee. So generally, you see that it's important to know your rights because it empowers you to ensure fairness and accountability in your job. It's true that the economy is, bad and all of that, and people are just trying to keep their job. But whilst you're trying to keep your job, do not allow your employer to intimidate you because he feels that you do not know your rights. But when they know that, yes, you actually understand your rights as an employee, there are so many things that they're not going to throw at you. So by understanding these laws and how they apply to your situation, you can always advocate for yourself, and in areas where you feel they are very difficult, of course, seek for legal advice. So you should remember before I end that, remember that your workplace should be a safe and fair environment for you. It's not somewhere that when you wake up, you're already thinking, should I even go to work? I'm going to face this, I'm going to face that. Mosquitoes are going to bite me. You're always treating yourself malaria because the environment is not even conducive. It shouldn't be that. It shouldn't be like that. So always seek professional legal advice, anytime it happens. Don't wait till... So when you find yourself in a situation that you're not comfortable with, say you're being harassed, speak to somebody immediately. Don't wait till when it continues, it lingers, and it may even also result to you condoning it. So try as much as possible to speak the moment something that you're not comfortable with happens, right? So I'm now going to allow my colleague to speak on the termination of employment. Gabriel, thank you.
Thank you so much.
Okay. So can I come in, please?
So hi, everyone. We see your questions in the chat box, and we'll get to them just after this session. So just like drop your questions, feel free. We'll get to them really, really soon. So you can go on, Gabriel. And please, if you have a slides to share or something, please, do you have that?
No. Unfortunately, I don't have that.
It's fine. Thank you. You can go ahead.
All right. So thank you very much, Judith, for that wonderful session. So I'll be speaking briefly on termination of employment. So we've been speaking about your rights as an employee under the law. But it is very important to state that, because I've been seeing a number of questions in the chat box, and people have been asking, okay, under the Labor Act, am I entitled to this or that? I know Judith must have mentioned it during the course of our session that the Labor Act itself does not apply to people who work in the professional industry, people who are professionals, people who are administrators. The Labor Act strictly applies to people who work, manual laborers and then clerical workers. So there are some rights that are provided for under the Labor Act that are not applicable to people who do this category of work that I've just mentioned. So we need to understand that these people who are professionals, who work in the administrative aspect, are governed strictly by their contract of employment. So it is very important that before you sign that contract of employment, you look at it thoroughly to see that all the terms and conditions are things that you can work with. So as of today in Nigeria, for people who are professionals, doctors, lawyers, auditors, or whatever they may be, there's no particular statute which protects their rights. Their rights and their duties are only covered by their contract of employment. So we need to know that. So I'll go straight to termination of employment. So before now, the common law doctrine of termination at will empowers the employer to fire for good, bad, or no reason at all. So before this time, an employer used to be entitled to fire any employee for any reason or no reason. He could just wake up in the morning and say, because you did not greet me yesterday, I feel like sacking, and then could proceed to sack that person that same morning. So under the common law, which governs contracts of employment, the employer does not have to give any reason for sacking an employee, or he may give whatever reason he feels like giving. So, but because the employer is presumed to have much more bargaining power than the employee. So recognizing the need to protect the worker who is in the weaker bargaining position, the International Labour Organization in its conference of June 22 of 1982, under the convention number 158, provided that the employer must always give a valid reason for terminating any employee's employment. So it is now a duty on all employers world over, including Nigeria, to always state a valid reason for terminating any employee's employment. So we need to understand some key terms when it has to do with termination of employment. There's terminations, simpliciter, there's dismissal, there's wrongful termination, suspension, and constructive termination. So what does termination, what does it refer to? Termination refers to where the employer or the employee, it is important to know that both the employee or the employer can bring an employment to an end. So both the employee and the employer can bring the employment relationship to an end in accordance with the terms and conditions of the contract of employment. Termination is not owing to any fault of the employee or employer. So Judith mentioned it earlier that in your contract of employment, it is always stated the notice period for termination. So either party can bring an employment relationship to an end by giving or by meeting the requisite notice period in the contract of employment. So if you go through your contract of employment, for instance, you see maybe in the employment, in the contract that, okay, if either party wants to leave the employment, you have to give 7 days notice, a month's notice, 3-month notice, depending on what is stated in the contract of employment. And then also, it could also be stated that instead of giving this particular period of notice, payment can be made in place of that notice period. So termination does not have to be because the person did something wrong in his employment, or he was insubordinate, or did something, or conducted himself in a manner that was unbecoming of him. So termination could be because the business or the company wants to reduce the number of workforce, or for any reason. So as long as the notice period is sufficient, then the employment can be brought to an end. The another one is dismissal. Dismissal refers to a termination of contract of employment due to the employee's misconduct, and this may be carried on summarily without notice and without payments in lieu of notice. So this is different from termination. It can be brought to an end without giving you any notice, and it is based on the employees or the employer's misconduct, and it can be done summarily without giving you any notice at all. Then there's wrongful termination. This refers to where an employer fails to follow the terms of employment in determining the employee's contract of employment. So where the employer fails to follow the terms of contract of employment in terminating the employee's contract, then it can be said that it was a wrongful termination. And this would ordinarily lead to the employee having a right to sue the employer for breach of contract. And then suspension, this refers to the placement of the employee in an involuntary paid or unpaid status for a temporary indeterminate period of time, pending investigation, inquiry, or further management action. So in essence, suspension is temporary withdrawal from employment as against permanent severance. Then I'll move on to constructive termination. Constructive termination is when an employee resigns as a result of the employer creating a hostile, intolerable, or unfavorable working environment. Because the resignation is involuntary, it is in effect a termination. In employment law, it is also called a constructive dismissal or constructive discharge. So I'll move on quickly to what will constitute dismissal. An employer with in most cases, employers would mostly choose dismissal of an employee instead of termination of his contract of employment with notice, where the conduct of the employee is of grave and weighty character, such that it undermines the relationship of confidence which exists between the employer and the employee. So in recent times, the courts have gone ahead to define what would constitute grave and misconduct of grave and weighty character. So in the case of Yusuf versus Union Bank of Nigeria, and then Union Bank of Nigeria Limited and Ogbo, the courts have held that the grounds on which an employer may dismiss an employee summarily to include gross misconduct, gross neglect of duty, disobedience to lawful order, and dishonesty, amongst others. The Supreme Court have also held that gross misconduct as conduct of grave and weighty character as to undermine the confidence which should exist between the employee and his employer, or working against the deep interest of the employer. So some of the things that can be categorized or considered as misconduct include, which would attract dismissal, include malicious mischief, which includes defacing, destroying, or damaging any property of the office. Then another one is any acts of insubordination. Then 2 is reporting for work under the influence of dangerous drugs or intoxicating liquors, or being in possession of same while on the office premises. Another one is habitual tardiness in arriving at the assigned place of work. Then another one is absenteeism without reasonable cause. And then involvement in any act unbecoming of an employee or that puts the office to disrepute. However, to validly dismiss the appointment of an employee, all that the employer needs to establish to justify his action is to show that the allegation was disclosed to the employee. So there are some procedures that the employer must follow in dismissing the employee for any of these things that I've mentioned earlier. So the employer must show that the allegation was disclosed to the employee, then that the employee was given fair hearing, that is, the rules of natural justice were not breached. And this is guaranteed under the Constitution. So before you dismiss anybody, you must give him an opportunity to be heard. You must hear his own side, his own story, before you proceed to dismiss that person. Then lastly, that the disciplinary panel followed the laid down procedure, if any, and the employee accepted that he committed the acts after investigation. So that is that for dismissal. So I will go on to constructive dismissal, because in some of the questions that were sent that we've gone through, there are some questions that people asked on bullying, that what will happen when an employee is subjected to bullying, sexual harassment. I think all those questions will be answered when we talk about constructive dismissal. So constructive dismissal must be traceable to alleged conduct or breach of contract by the employer. So this means that in this case, constructive dismissal can be said to have happened due to the fault or misconduct of the employer. So it must be traceable to the employer. Thus, the court will adopt a reasonable man's test when confronted with such claims. So when you file a claim in court that, okay, I had to resign from my employment because of what my employer did, maybe the employee was subjected to bullying, sexual harassment, the court will not just take it hook, line, and sinker. The court would have to apply a test, a reasonable man's test, that, okay, this particular thing you said you were subjected to, if any other man out there, a reasonable man, was put in that same situation, would they have been forced to resign? So we get to know that most times, instead, employers use this tactic to dismiss employees because they do not really want to give the person a notice period or to terminate his contract or to dismiss that person straight out straight away. So what they do is that most times they do all sorts of things to frustrate or to force the employee to resign. So in this case, all hope is not lost for the employee. You can still file a case against the employer that you were forced to leave that employment because of the grievous or all sorts of conditions that you were subjected to in that employment. But be careful, because the court will not just look at your subjective interpretation of the circumstances. The court will have to look at what a reasonable man would have done in that situation. So constructive dismissal may occur in any of the following instances. Number one is workplace bullying and harassment, which may be sexual or non-sexual, physical or verbal. Another one is placing ridiculous, extraordinary, and unreasonable work demands and expectations on an employee to pressure him or her into resigning. Another one is unilateral violations to the terms and conditions of the contract of employment without any notice to the employees or without the consent of the employee. So for some certain situations, like the person who mentioned that his salary was reduced by 30%, the law does not allow the employer to just take that unilateral decision. It is something that has to be with the consent of the employee. So whenever, let's say, for example, the employee under his contract of employment is entitled to 500,000 per month. So it's not, the employer cannot just say because of one thing or the other that he wants to reduce it from 500,000 to 300,000, or to just demote the employee for any reason. So it has to be with the consent of the employee, and the person has to be given notice of that. So another ground for constructive dismissal, meaning that the employee can leave the employment, is when, like I said, a significant reduction of the employee's compensation and or demoting the employee for unjustifiable reasons. So there are situations where the demotion or the reduction can be justified, but if it is unjustified, then it's a ground for the employee to leave the employment and then sue the employer. Then another one is exposing the employee to danger and unreasonable hostility. Another one is disciplinary proceedings which are manifestly unjust. Then suspending the employee indefinitely with or without pay. So the employee may resign over a single serious incident or over a pattern of incidents. So generally, a party, the employee seeking relief, must have resigned soon after an unreasonable situation was imposed. So you should not wait for like 2-3 years before you leave that employment. So as soon as the employee has been subjected to that unreasonable situation, is entitled to leave that employment and sue the employer. So a successful plea of constructive dismissal amounts to and has the same effect as wrongful termination, which in essence means that the employee will be compensated in appropriate damages where this occurs. So that is all about termination of employment. Thank you for listening.
Wow, thank you so much, Gabriel. That was really, really, wow, enlightening. I've learned a whole lot. So many tables have been shattered already, to be honest. And it looks like some bosses are going to jail really soon. So moving on to questions and answer session. We've gotten a couple of questions. So if you asked the question earlier, because I missed some already, can you just like resend them in the chat box so that we can address all of your questions? So first question that I have here is a verbal offer of employment binding. Okay, so this person is asking if, because you mentioned earlier when you were speaking that a contract could be maybe documented or verbal. So is this verbal offer of employment, is it binding really? Like, can you just hold on to, or how does it work in terms of, if it's not documented, how does it really work? Like, how can you hold someone on their words? Pretty much, that's the first question. So, hi, Gabriel. Will that be you to answer that?
All right. So yes, like Judith said, when she was making her presentation, so a contract of employment can be verbal, can be written, can be implied, and can be expressed. But I think it is safe to have it written down, unless you have someone who is ready to testify or to stand as a witness that I was there when they agreed on so terms. But if there's nobody to witness or to stand to testify to that, that means it is the word of the employer against the employee. So you can deny and say, I never employed you in this to work for me. So it is better it is in writing. So that will serve as evidence that yes, both parties signed to this terms and to this contract of employment. So it is safe to put it down in writing. So if that has not been done, you can talk to your employer to put it down in writing. So this is safe for the employee, as it will protect the rights of the employee and to state the terms. The terms will be clear. Okay, so what am I entitled to under this contract of employment? So everything will be stated. And if there's a particular thing, maybe your leave bonus, like someone asked in the chat box, is not stated, you can talk to the employer, okay, I need this to be in my contract of employment. So if he does not want, it's just that in Nigeria, the employee is in a weaker position to negotiate contracts of employment. So most times they say, if you cannot take it, then you have to look for another job elsewhere. So most times employees just take whatever they say. Well, it is what it is. Contract is contract, agreement is agreement. So it's better to have it down. Yes, in writing.
Thank you so much. So I mean that answers your second. Okay. Judy,
sorry, just to add to what Gabriel already said, I think that in events that the person already has like an employment going on, but it's not written. There's no like written terms of employment, and it needs to show that there has been an existing, employer-employee relationship here. I think that one way is to show that you have been receiving maybe payments, maybe you show your pay slip or something that this person has been paying you for this work, or if you can prove that you have actually been doing, depending on the nature of the job, this is what you have been doing. That way it shows that there has been an existing, employment, even though it has not been expressly written down. But just like I said earlier, and just like Gabriel also said, it's advisable to have it written because it's easier for you to make reference to the terms. Thank you.
Okay, thank you so much, Judith. So I hope that answers your question for Lafash. Moving on, as a question on money. So can you sue a company you're working for because of underpayment? So you feel like you're not being paid well. Can you sue? Is that legal? Or you just pack your load and leave, literally?
So, okay, let me answer that. So, yes, you can sue, but I would, like I said, for most people who are professionals, your contract, your employment is basically governed by your contract of employment. So, if it's stated in your contract of employment that you're entitled to so amount as your salary, and then whilst you are in the employment, the salary is reduced, yes, you can sue the employer because that is against the terms of employment. But I think it is better to explore internal resolution mechanisms at first. Write to your HR, put it down in writing, make a formal complaint to your HR and set up a meeting, try to set up a meeting with the management and see if that can be resolved. But if not, yes, you can sue, you can engage a lawyer who can help you file an action in court for breach of contract, because that will amount to breach of contract. So you can sue the employer and then get compensation for the breach of contract. But it's best to explore the internal resolution mechanisms. And then it's also because if for you to sue your employer, that means you have gotten a job somewhere. So be be ready to leave that employment. You can't sue them and remain in the employment. So.
Right. Thank you so much. So just to read, because it said if you can sue if it has been mentioned in your contract that after 6 months would maybe increase or something. But if that is not there, like there's no statement about increase or anything like that, then you might want to just put where they'll pay you what you want to be paid, literally. Thank you so much, Gabriel. So the next question. Someone is asking, what is the best way to handle employer refusal to remit employee pension? So our employer does not want to, or his employer, that's Timothy, does not want to remit his pension. How is the best way to handle that?
Okay, so I would say that it's advisable to first do a formal complaint, to the HR. It's always good to explore this internal mechanism so it doesn't seem as if you just, went straight to, because you can just sue or report and all of that. So first off, write to the HR, ask why they are not remitting your pension and all of that. And if you're not getting any positive feedback, then of course you can report to the Nigerian Pension Commission, right, which is the regulatory body in charge of pensions in Nigeria. So you can report to them when, of course, you have applied to the HR and there's no positive response. You write to the Nigerian Pension Commission, and if there is still no positive response or outcome from that, then of course you can institute an action, because if your terms of employment states that your employer is supposed to be contributing to your pension, then he should be contributing to the pension. There is no reason why he shouldn't remit the amount for pension. So yeah, these are the options that you can you can explore. And it's always advisable to, ensure that you seek. There are times some of these complicated issues, it's just better up to seek legal advice, because your situation may not be, people have their peculiar situation. So may not use what has happened to Mr. A to, apply it to your own situation. So it's always advisable to, of course, seek professional advice. Thank you.
Okay, thank you so much for that. Moving on to the next one. Someone is asking, does the employer have the right to delay staff salaries without stating why? Just to tie down, that's one other question that we got. And the question is, oh, my boss is owing me a month's salary. Can I take legal action for that? So just to answer those together. What do you do when you're being paid late or not even paid at all for an extended period of time?
Okay. So I think, like I've been saying, explore internal mechanisms, make your formal complaints. So if there's a particular date that has been mentioned in your contract of employment as a date of payment of your salary, and then it goes beyond that, and then there's no explanation from the management, you can write to the management, and then I'm very sure the management would have something to say. But if they are refusing to do that, then you can take it up against them, then consult a lawyer, then the lawyer would know what to do concerning them. So then for the person who is being owed a month's salary, yes, also you have to explore the internal resolution mechanisms, go through the channels, and then if nothing is being done, you can write a formal complaint or even get a lawyer to help you write a demand letter. You can write a demand letter for the salary, and then if you are not getting any positive feedback from the company, then the law allows you to file an action against the company to recover your salary. You can do that at the National Industrial Court, or even report the company to the Ministry of Labor and Employment. So those are the options that the person can take.
Okay, so does this also work for maybe an ex-employer? So you don't longer work there, but they are still owing you like for maybe a month or two that you worked with them.
Yes,
Is it the
it
same
does.
process?
Yes, it does. You can file an action to recover the
Okay.
unpaid salaries.
Okay. So maybe just to say more on that is so you're talking about filing and filing and filing. So how exactly can you file this complaint? How does it work? So I think that's Adebayo, you're asking for the process. How do you go around it? How do you investigate it? How do you resolve it? Like the step-by-step process to filing a complaint or grievance, really? How does that work?
So I think that most companies have like a set out procedures or policies, like a chain of command when you have an issue or something that you are concerned about. In fact, most companies have like the HR department, and they have like a procedure where file like a complaint, either through emails or written applications or what have you. So depending on what is applicable in the company. But if there's no stipulated mode, then doing a formal, application, just state the facts of whatever it is that transpired, what are your grievances, and what the company should do or what you expect from the company, and submitting it to either the HR or the managing partner or whoever is like in charge of the staff affairs. That is for the internal procedures, right? Of course, if you're going to institute an action in courts, you definitely need a lawyer to, guide you on that properly. So, but talking about the internal mechanisms now, if the company has like a laid out procedures, then you can just follow that. Either send an email, copy all the people that needs to be copied in the email, and then follow that up or do like a written application to the HR or the head of departments, or however it applies to the company. Yeah, so.
Okay, thank you so much. I hope that answers your question, Adebayo. So moving on to the next question. Someone is asking, most organizations don't give employment letters or appointment letters. I don't know about that. But the question, in the case when no employment letter was given, can an employer demand a 1 month notice of resignation? So
Sorry,
no
I didn't get
contracts,
that.
nothing.
Is it like, can it be stated
In the
in
case
the
where
letter
you
of
don't have
employment? Sorry?
sorry, what did you say?
I'm asking, like, is it that the employer, whether the employer can state in the letter of employment that he demands a 1 month notice?
No, so this person is saying they didn't get an employment letter at all.
Okay.
But if they want to give, can the employer demand a 1 month notice of resignation?
Okay, Judith, can I answer that question?
Okay, yes, go ahead, Gabriel.
So in the absence of any period, anything stated to that effect in the contract of employment, or where there is none, this is where section 11 of the Labor Act will come in. So where there is nothing stated like that in the contract of employment, then the provisions of the Labor Act will come in, and that's section 11(1) and 2. So can I be permitted to read it?
Oh, yes, please.
So section 11(1) and 2 of the Labor Act states that either party to a contract of employment may terminate the contract on the expiration of notice given by him to the other party of his intention to do so. Subsection 2 states that the notice to be given for the purposes of subsection 1 of this section shall be a 1-day notice where the contract has continued for a period of 3 months or less. Then B, 1 week notice where the contract has continued for more than 3 months but less than 2 years. Then C, 2 weeks where the contract has continued for a period of 2 years but less than 5 years. And D, 1 month where the contract has continued for 5 years or more. So in the absence of anything stated like that in the contract of employment, these are the notice period that will apply. So that should answer the person's question. So if the person has been in that employment for more than 5 years or more, so the employer or the employee is obligated to give a 1 month notice.
Thank you so much for that detailed answer, Gabriel. So this question, is it compulsory for an organization to provide working tools for its employees, tools like laptop, desktops, things like that? Is it compulsory? Do you have a right to working tools from your employer?
Okay, so I think that this actually depends on the terms, right? It's not every employment that requires the employer to provide working tools for their employees. So it largely depends on the terms. There are companies who tell you you can't use your personal laptop. We have to provide you with a company laptop. We have to provide you with a company phone and whatever you. So it depends on, the terms that have been agreed. It's not something that one can enforce where the company has not made such provision for that. Yeah.
Okay. Thank you so much. So you had mentioned earlier that when you're trying to maybe sue a company or something, that you should know that you don't have a job there anymore. So Antonia is asking, is it really important for me to resign before suing my organization?
It's commonsensical because who will still be in a company and you're suing them? Anyways, Gabriel, please, I think.
So I don't think it is compulsory that you leave your job to before you can sue the company, but I know the employers also will have their ways of frustrating you out of the job.
You'll be blacklisted now.
So you don't have to resign before you sue. So, but there are ways by which they can also frustrate you whilst you are in the company.
Okay, so common sense says, please just
Discipline.
resign, I beg, so that you have
Yeah.
your sanity. All right, interesting. Also, thank you so much for that. So someone is asking, on what ground can I request an increase? Because I've been working for this company for 2 years now, and well, they've not increased salaries. So on what grounds can I request for increase in salary?
So I'm going to say that increments or raise, generally still are the subject to the company's policy, right? So, but if as an employee, you think that you're bringing value, tremendous value to this company, you have done things that have attracted or yielded profits, growth to the business or the corporation as a whole, so it's within your discretion to point out these things that you have done for the company. Have like a conversation, meet with, try as much as we may even extend or go beyond the HR, speak to whoever is in charge, maybe the CEO or the head or whatever, try to have a conversation with them, be polite at it, highlight the values that you have brought to the company so far, and make them see reasons to give you a raise. There are ways that if you say all of this, they will even be scared that you leave their company. And when you leave, they're probably going to be at loss. So it's always weird when you're not generally bringing anything to the company and you are asking for a raise. So it's better off, or it's advisable when you are bringing value and you make it known, you state it, you tell them, speak to them, ask for meetings, speak to the head and say, oh, this is what I've done in the past 2 years. I'm working for this company. As a result of this company has gotten to this peak. And you feel that without even necessarily specifying that you need a raise, they already know that this is where you're driving at, right?
Yeah.
So I think it's advisable before you start thinking about raise, you should be able to highlight the values that you have brought to the company, Yeah.
Thank you so much. So it's not about the length of time in particular, but like how much you've done in that period of time.
So again,
Okay,
I know
so
that there are I know that
Okay.
there are also companies that specify, like, maybe after working for a particular period, you'll be
yeah,
entitled to promotion as well. So if that is the case, they just say if you work for 2 years without any conditions, you should be entitled to a promotion. Then we can enforce that right? But if there are conditions, okay, maybe you must have, increased the clientele, or you must have done this project, or you must have achieved this milestone before you be entitled to promotion. That's why I said at the beginning that it depends on the company's policy, what is obtainable. But if there's no specific, conditions, then of course stating or pointing out the values that you have brought to the company would go a long way. So yeah.
Thank you so much. Gilbert, you wanted to speak on that?
Yeah, so she's already spoken my mind, so there's no point.
Okay, awesome. All right, so there's something that companies do, and someone is just asking that, saying things like, "Oh, we will give you more money, but we don't have money." So is the fact that the company is not making money enough reason for them to just say, "Oh, we can't give you a raise because you're not making enough, we're not making enough money," quote. Is that a valid reason to give to an employee?
So I think for me, I think we should not forget that whatever an employee is doing in his employment is governed by his contract of employment. So, and there are two types of contracts of employment. There's a fixed term employment, there's an indefinite employment. So, for example, if the person is on a fixed time employment and it's been stated that, okay, you are going to be working for this company for a fixed period, say 2 years, and these are the times of employment, you are entitled to some amount of money as your salary. Then at the end of that employment, the person has to go. So that's the case for contract staff who work for the banks. So they are placed on a fixed period of employment. So at the end of that, they go. But for an indefinite employment, and it is stated in contract of employment that this is how much you are entitled to. So for that period of time that the person is there, unless it is expressly stated, like Judith said, that okay, after so period of time, you are entitled to be promoted, and this is what your salary is going to be. If that is not stated in the contract of employment, the company does not have any reason, does not even have to give you any reason why your salary is not increased. If you are not okay with that, you can leave the employment. Because it has been stated in the contract of employment, this is how much you are going to be entitled to. So if there's anything, if in the absence of anything stating that after so amount of time you'll be entitled to, that is what you are entitled to. That is it. It's a contract. So the company does not have to give any reason why your salary is not increased. Well, the only thing you can do is to build a case for yourself, make a case for yourself that this is what I'm adding. I believe that once a person is adding value to that company, the company ordinarily will want to keep the person and will want to increase the salary. Because I've been in that situation before. I was working with a law firm here in Abeokuta, and I was not getting enough. And because of the value I was adding to the company, I told my boss that, see, I'm going to Lagos, so I have an interview in Lagos, and I've gone for that interview. This is how much they are willing to offer me, which is much more than what you are paying me here in Abeokuta. But if you would increase my salary, I don't feel like going to Lagos. I prefer to be in Abeokuta. But if you would increase my salary, then I can stay. Immediately at that at that discussion, increase my salary from what I used to be paid. So it was not under any obligation to increase that salary, but because of the value that I was bringing into the law firm, he had to do that. But if you're not bringing value and you're expecting your salary to be increased, it's going to be a long thing. So that's my response to that person's question.
So
Interesting.
let me just quickly add that there are also times where companies face a bit of challenges, and ideally the company may want to lay off their staff or their workers, right? So sometimes some of these companies, what they do is that, they call you to have a conversation and say, okay, because of this problem, you have two options: either we lay you off or reduce your salary. So that way they're already having like a conversation and they're making it open for the employee to decide. So if you weigh your options and you feel that, oh, the labor market is tight, trying to get another job may be quite difficult, you may agree to them reducing your pay, or you just, leave the company. So I think that could also be a situation. So in that situation, if the company, with your consent, they can reduce your pay because they are not getting profits as they should. That's just what I wanted to add to that.
Okay, thank you. Thank you so much for that. So someone is asking, all these sue your company, sue your company, sue your company. How much does it take to actually sue, please? Let's know what we're getting our heads into. Okay,
Gabriel,
wow.
do you want to review your professional fees, Gabriel?
No. No, I think it depends on the kind of lawyer the person is getting. So if you are in Lagos, for example, and then you want to get a lawyer, depending on, no matter where the person's practice is based. So it is discretionary. It depends on what the lawyer would want to charge. So there's no particular amount of money that a lawyer can charge. So it's based on your negotiation with the lawyer. And we have to understand that some law firms also have standard fees for some of these things. So that some of them are non-negotiable. So it depends
And
on
of
the
course,
lawyer.
it also has to be in accordance with the legal practitioner's remuneration order, right? There's now a provision on the fees that legal practitioners charge. So yeah, but I would always advise to explore the alternative disputes mechanisms first. It is way cheaper, and it will always maintain whatever relationship that you have with your employer. So first off, before you start rushing into litigation, it's highly advisable to explore the ADR mechanisms first.
Okay, but can we get like a range or something, Or it's TMI.
And there's no particular, like I said, there's no range actually. Depends on what works, what the lawyer is willing to take from the client. So a lawyer could say, I will charge you 1 million, and that one would say, I'll charge you 100,000. So it depends on what's the kind of discussion and what they conclude on. So there's no particular range.
Okay. But I mean, if anyone on this call needs like your services, they can reach out to you privately to know how much you charge and things like that, right?
Yes.
Okay. I say lastly, everything for God. Okay, interesting. Thank you so much. So if I've not asked your question or I missed it, you can just drop it again so that we get them answered before we leave this call. We still have a couple minutes to take some more questions. So if I have not answered your question, please. Oh wow, this is quite a lengthy question. I'll just read it out. I resigned from my previous organization. I guess that's what you meant to type. And my last day on the job was 25th May 2024. Just a moment, please. Let me. Okay. Okay, so I think she wants to ask a question verbally, so I'll just have you go then. Precious, if you want to speak and speak. Hi, Precious, please go ahead.
Okay, good afternoon, CareerBuddy. Thank you so much for this amazing section. But actually, I don't know if you could read the comment. The question was actually directed to you, like a confidential question. So I don't know if I could get the response via chat back to me. I stated the reason.
Okay. Well, I'm not a legal practitioner, so you might need to. Okay, let me just check out.
Okay.
Yeah, because I can't answer you privately, except if the speakers are willing to give you answers after the call, maybe you can reach out. I don't need to do that, but I'm not a legal practitioner, so I can give you answers to that, if you understand.
I think she can also send the questions privately to any of us. Maybe she can
Okay,
send to me or to Gabriel.
I think okay, that works then.
All right. Thank you so much.
Thank you. Thank you, Judith. Okay, so another question. What can I do if an employer is deliberately not complying with regulations, such as giving their employees pension, blah, 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 blah. So what can I do if my employer does not want to give me stuff like pension? So, and she's saying that the HR has explained the need for compliance, but the employer is saying no. Okay. So,
and so the best thing is to report. The employees can come together and report that employer. They can do an anonymous reporting to the Pension Commission, the Ministry of Labor and Employment, and I'm very sure they will take it up against the employer.
Okay, thank you so much. So Antonia is asking, what is the maximum number of days of medical leave an employee can take? I think it's based on your contract, but yeah.
Yes, it's based on contract of employment.
Yeah. So maybe just to ask, because just based off this now, what if maybe is there like a general or a limit or something that I can ask? For example, I get a contract and they give me 5 days of medical leave. Can I say, oh, I want 20 days, not 5 days, so I want 25 days? Like, is there like a limit of medical leave to request for? At this point, I haven't started working with you. I'm still trying to like negotiate.
Yeah, you can do that at the negotiation table. You can, if the employer would agree, because it has to be agreed, then both parties have to agree. So if at the negotiation table you say you want 25 days and the employer sees the value in you, the employer can decide to agree with you. If not, whatever is stated in the contract of employment and you sign is what you are entitled to.
Okay. So there's no like legal cap or something that you can't go beyond this amount of days. Whatever you want, you can ask for.
No, for this set of this category of workers, there's no particular. It has to be governed by a contract of employment. So the Labor Act, the provisions on sick leave, medical leave in the Labor Act does not apply to people who are not manual laborers or clerical workers. So other people, yes, governed by your contract of employment.
Okay, interesting. Thank you so much for that. So again, if I've missed your question, please just resend it so that we answer that before we leave. One other question, though, is it okay? Because there are some employers that like threaten their employees with like, getting sacked. So if you don't, they'll say, I'll sack you, I'll sack you, I'll sack you. Is it okay to be threatened by your employers to be sacked? Right. And to add to that, someone is asking, can I be sacked if based on the fact that I gossiped? Like, is gossiping a valid reason to be sacked or fired or something? Yeah. So you can just answer that together. Thank you.
So like I said, what I was talking about termination of employment, I mentioned those things that the courts have defined and to be. So the employee can be served based on, can be dismissed or sacked based on his performance or misconduct. So what would amount to misconduct is subjective. But the courts have also helped in that wise to say that, okay, what will amount as misconduct of the employee has to be something that is of grave and weighty character. And the courts are in so many cases have gone ahead to define what amounts to grave and weighty misconduct of grave and weighty character. It has been said that, okay, the employee may be dismissed summarily based on gross misconduct, gross neglect of duty, disobedience to lawful order, malicious mischief, destruction of the company's property, any acts of insubordination, reporting for work under the influence of dangerous drugs or intoxicating liquors, or being in possession of same, habitual tardiness, absenteeism without reasonable cause, involvement in any act unbecoming of an employee or that puts the office to disrepute. So I think this act of gossiping will come under this last one, involvement in any act unbecoming of an employee or that puts the office to disrepute. So it depends actually. It depends. So it's left for the courts to decide if that particular act of gossip, and then to what extent was the gossip? Was it something?
What are you gossiping about?
So we need to understand if it was just something that you categorize as a simple gossip or something that can bring down the company. So it depends.
So just
it
to
could be.
also add, sorry, Gabriel, are you done?
Yes, I'm done.
Okay, just to add that where I take that gossip to be that probably one of your co-workers have reported you to, your boss and stuff like that. So in that situation, you are also entitled to fair hearing. Your boss should, call you to hear your own side of whatever it is that has transpired. Do the proper investigation in accordance to how the company runs their investigation. Sorry about that. So before they can go ahead to.
Yes, that's why I said that to validly, because if the person is not given a right to tell our own side of the story, the person's fundamental right of fair hearing has been infringed upon. So that kind of dismissal would be unlawful. So a panel has to be set up to investigate whatever the person has said. I said it earlier that a delegation should be disclosed to the employee, that the employee was given fair hearing, then that the disciplinary panel followed the laid down procedure, if any. So they must follow that procedure before the person can be sacked. But if the person is sacked without following all these procedures, that dismissal will be unlawful.
Okay. Thank you so much for that. One other question is, so you were talking about how that in some companies, people work overtime, and if you're having to work overtime, they should probably pay you or something, but that's really not the case. So someone is asking, how do I uphold my rights to work only 40 hours in a week? Like, how can I stick to that, right? Is it right for my employer to impose extra working hours on me without pay?
No, I don't. I don't think it's right, because that would be in breach of the contract of employment. So unless
Okay,
it is
but I mean,
stated.
so, okay.
Okay, I can hear you. Go
So what
ahead.
can be done? So what can be done? Because obviously this happens a lot. It's quite really common for you to work overtime and it's like, I'm your employer. Sorry, you have to do the work literally. So what can be done literally to maybe, I don't know, fix this, or yeah.
Yeah, I think it's simple. It's that you put in a formal complaint to the HR or to the management. So, but if nothing is being done, then you can sue the company for breach of contract, even whilst outside or whilst the person is in that employment. So
Okay.
that's the option available, because
Thank
you can. Yeah. Welcome.
you. Okay, were you done?
Yeah, I'm done. Oh, yeah, I was going to add that the employee can also report to the Ministry of Labor and Employment. Report the
Okay,
complaint to the Ministry of
awesome.
Labor.
Thank you. Thank you so much. So that's about all the questions that we have. I don't see anybody sending a question that has not been answered. So if I did not answer if I did not ask your question specifically, it's because it has been either been answered or someone has asked something similar. So if there is still anything else that has not been mentioned that you want to ask, you can please drop it. But yeah, thank you so much, Judy. Thank you so much, Gabriel. I really learned a whole lot. Hi, Precious. Have you gotten to send your question? Or hi, Gabriel. Hi, Judy. Did you get any question from Precious privately?
Yes, I did. As a matter of fact, I'm
Okay.
trying to respond to her now.
Okay. Awesome. Thank you so much for that. So thank you so much, everyone, for joining. I hope that you were able to get a whole lot from this session. Thanks again, Judith and Gabriel. So moving on, we have just one or two final things to do before we get done. We have, okay.
Yeah, I asked a question basically on the rights of staff being owed salaries. What are the actions to take?
Oh, so it's been addressed, actually.
Oh,
It's been addressed.
Okay, so
but
I'm just going to give a quick recap on that. So if you're being owed, you can explore the internal mechanisms of, applying formally to your HR to ask why, or, to demand for your salary. And if there's no positive response from them, then you can go ahead to can seek for legal advice, file an action in courts. But it's always advisable to follow the laid out procedures of, channeling your grievances in the company first before, resorting to filing an action in courts. But again, like I mentioned earlier, the Trade Dispute Act has made provision for alternative dispute resolution methods of settling trade disputes. You can have a mediation. Both parties can just agree to have a mediator to preside, or a conciliator to preside, or it can also be referred to the industrial arbitration panel before moving to the National Industrial Court. Like I always say, it's better off to explore these ADR mechanisms first before, going into the litigation aspects, right?
So
I don't know if that answered your question. Okay, Gabriel,
maybe
yes.
I should add that, and this is where the trade union also comes into play. If you are a member of a trade union, this is where they have to play their role. So the trade, you can report the company to the trade union, and then the trade union can set up a meeting, like Judith said, mediation, arbitration, all of that. So they can they can represent you in that situation to try to see what they can do, and then make sure the company pays your salary. So this is where the importance of joining a trade union comes into play. So if there's a trade union concerning what you do in that company, you can join such a trade union, and I'm sure they'll be able to help you in this kind of situations.
Okay, thank you so much. Thank you so much.
Thank you. Thank you so much.